Welcome to the New Books Network.
Welcome back to New Books in Political Science, a podcast on the New Books Network. I'm Susan Liebell at St. Joseph's University, and today I'm joined by Dr. Anthony Michael Kreis to discuss his new book, Rot and Revival: The History of Constitutional Law in American Political Development, published by the University of California Press in 2024. One of the great divides in American judicial scholarship is between legal scholars who take the justices at their word and assume that those words define the law, and political scientists who dismiss all judicial arguments as smokescreens for partisan bias and wider political forces. Today's guest has written a book that bridges that divide. In Rot and Revival, Anthony Michael Kreis uses methods from history, law, and political science to theorize and document how politics make American constitutional law and how the courts affect the path of partisan politics. Understanding American constitutional law means looking at the relationship among dominant political coalitions, social movements, and the evolution of constitutional law as prescribed by judges. For Kreis, constitutional doctrine doesn't exist in a philosophical vacuum. It's a distillation of partisan politics. Rejecting the idea that the Constitution's significance and interpretation can be divorced from contemporary political realities, Kreis uses tools from law, history, and American political development to explain how American constitutional law reflects the ideological commitments of dominant political coalitions, the consequences of major public policy choices, and the influences of intervening social movements. For Kreis, constitutional law is, quote, best understood through the diachronic lens of American political development and the concept of political time. Kreis concludes that the courts have never been and cannot be institutions lying outside the currents of national politics. Anthony Michael Kreis is assistant professor of law at Georgia State University College of Law, where he teaches constitutional law and works at the intersection of law and American political development. He earned his undergraduate and law degrees at the University of North Carolina at Chapel Hill and Washington and Lee University, respectively, and his PhD from the School of Public and International Affairs at the University of Georgia. He's one of my favorite scholars on social media, in part because of his analysis of American politics and Georgia politics, and I'm delighted to welcome him to the New Books Network.
Well, I'm so glad to be here, and I appreciate the opportunity to speak to so many folks who are interested in the newest books in political science.
Well, and it'll also be to people interested in law and history, because this book really isn't just about politics. It's about all of these things together. And I really appreciated reading it. And I have to say, I learned an enormous amount from the book that will both impact my scholarship and also my teaching. So the book is highly accessible and recommended to everyone, really. This is a book that you can just pick up and read. Honestly, I read this at the beach.
I love that.
Okay. And so others can do that too. And this is something you can assign to an undergraduate as well as graduate student. It's equally important.
Yeah, actually, I think that kind of idea is really important to me to hear other people say, because I think one of the things that troubles me about the way we talk about constitutional law is that in the academy, we talk about it in these kind of silos, right? You have political scientists talking about it to other political scientists, and you have historians talking about it to other historians, and you have law professors talking about it to other law professors. And there's there's probably increasingly so dialogue between these different academic traditions and fields, but I want more of that. And I also think it's important that we talk to each other in plain language, right? Where you can enjoy this kind of theory of constitutional law or constitutional history or American political development as a subfield, and actually enjoy the work that's being done in a way that's publicly and easily digestible and engaging. And to me, that's kind of the whole goal of this book, is to speak to multiple audiences in a way that they find to be interesting and enthralling, and that pulls them into the academic side of what I'm trying to sell to folks across various disciplines.
Now, I think of your book in two contexts, Anthony. One is that there is an increasing appetite in the public for people explaining the law. So you look at podcasts like Amicus and Strict Scrutiny and 5-4. How is it that my daughter, for example, can explain Chevron doctrine to somebody very easily only because she's been listening to this podcast? She hasn't gone to law school. But so I actually think this is a moment in which, because of the increasing polarization of the court, your book is even more important because there has to be this conversation. And the second thing I wanted to say is I've interviewed some amazing legal scholars on this program. I will not name them. And either on or off the air, I have asked, is today's moment changing how you teach constitutional law to your law students? And almost all of them have said no, that they have continued to teach it the way I had it when I was in con law, and have it presented in this way that is frankly no longer, I think, true. Anyway, your book does a lot with that, and I want to start with I think the case that is maybe the most famous to people and the one that you open the book with, which is Marbury versus Madison. And this case is usually praised. It's a showdown between the president and the Supreme Court, and the court establishes judicial review, swelling music now. And the ability to void laws that are inconsistent with the Constitution gets established. And in some tellings, the court is acting against its own self-interest. And we're supposed to be grateful for unelected justices looking out for the nation's best interest. But you have a very different story to tell about this 1803 case. And I was wondering if you could do a short version of that, because I really do think it sets the table beautifully for the book.
Yeah, so I think, we always talk about Marbury versus Madison as an isolated jurisprudential development that popped out of nowhere in 1803. But really, the story begins in the election of 1800, and this bitter fight between the Jeffersonians and the Federalists. And so you had the kind of beginnings of a really robust two-party fight over a presidential election. And the Federalists lost in that election, and they attempted to stack the federal judiciary with their co-partisans. And that, of course, included, William Marbury. William Marbury being one of these midnight judges of the peace who was appointed to kind of give other Federalists not just a position in the federal judiciary, but to reward people who are ideologically aligned with you. But he didn't get his commission because John Marshall, who was Secretary of State at the time, failed to do so. Ironically, John Marshall was also simultaneously, for the last few weeks of his time as Secretary of State, also serving as Chief Justice of the United States. So, never. It's probably never really a good job to try to do two jobs at once, right? Like maybe he should have just stuck to one. And so, of course, that's interesting because he's the proximate cause of the failure of the commission to be delivered, but yet he's sitting in judgment later in the Supreme Court over the action in an attempt to force the Jefferson administration to turn this over. So we've got some judicial ethics problems there. Of course, that's kind of funny because we've got some judicial ethics problems now. Nothing's new under the sun. And so, right, basically, as James Madison, who's now in charge in the new Jefferson administration of handing out these commissions, refuses to give Marbury his commission because he doesn't want to give it to somebody who's aligned with the Federalists. We get this initial original jurisdiction action between Marbury and Madison for a writ mandamus to compel the Secretary of State to deliver this commission. And so one might think that the United States Supreme Court, which is stacked with people who are more aligned with Marbury because of their political ideologies, might be inclined to say, okay, Secretary of State Madison, you must deliver this commission because that's just, it was a dual, he was duly appointed and that's just that. And they didn't do that because there's risks involved there. Of course, if they do order the Jefferson administration to deliver this commission, Jefferson could order the Secretary of State to just put his thumb in the eyes of the justices and say, we're not going to do it. That, of course, would significantly undermine the power of the federal judiciary and the United States Supreme Court. On the other hand, they can't really give Marbury a loss outright because that would also kind of be a damaging thing to do to somebody who is their co-partisan. Now they've got this out, though, which they can kind of ideally say, well, we're going to interpret the Constitution in such a way that the statute, which gives us the authority to issue this writ, unconstitutionally enlarges our jurisdiction. So you have this dynamic where the court appears to be narrowing their power, but they're actually protecting their power from just being rejected by the political branches, and so it's kind of an act of political survival. And then they can also, not say to their friend who, in Marbury, well, we've handed you a huge loss too. They can kind of have this optimal out, off ramp. And so when we celebrate this case, we do so for this kind of apolitical decision making. It's very political. It's very strategic, and so it's not kind of this neutral outcome that we've always been kind of led to believe or taught to believe. And if there was any doubt about that, this was also a decision that was made in the wake of judicial reform legislation passed by the Jeffersonians after they came into power, which canceled the United States Supreme Court term, which kind of played with a number of justices. If it abolished a number of appellate courts, and it forced the justices to have extra duties, including circuit riding, which they used to have to do, right? Which was basically going around the country and hearing cases on appeal as an intermediate appellate court. That duty was taken away, and now they were forced to do that again. All of these are shots across the bow for the court to come to heel to the new dominant political coalition that emerged victorious from the election of 1800. So far from being this kind of virtuous, apolitical, neutral decision that was done in the name of objective constitutional analysis and far removed from politics, this was definitely a decision that was steeped in partisan political considerations. And so that is a story from the very beginning of the federal judiciary, and it's one that has carried it on throughout American history up until and including today.
And the book is focused on 1824 to 2022. And as the example that you just gave demonstrates, you are always looking at the importance of these presidential elections and what table has been set by those partisan forces. And I want to get to all of that in the argument of the book, but I want to back up because you've used a couple of terms that some of our listeners know really well and some of them have no idea. So first of all, let's talk about what American political development is. In a law school class, you would read the cases, you would summarize the arguments being made in those cases. It's very, very careful textual analysis. It's akin to like poetry and being very, very precise about your terms. But American political development is different, and it's not something that legal theorists generally use. So back us up, tell us what American political development is, and also how did you come to this as the sort of key for you that connected up all of these ideas?
So American political development is a subfield of political science, and it means a lot of different things to different people. So there will be different folks who all consider themselves American political scientists or American political development scholars, but who might have a different take on exactly what it means. But I think to me, the main theme that we all somewhat agree on is that time is really important, and that we really can't study and understand American politics through one-off cause and effect relationship. So some people may want to study, well, how, here's a good example that everybody's been talking about this year with vice presidential picks. How many votes can a vice presidential candidate bring from their home state on average? And so there will be all sorts of studies, right, where people are kind of looking at different things and isolating variables in order to figure out what that answer is. And that's not exactly what American political development scholars want to do. We see as cause and effect relationships as building slowly over time. Part of the idea there is that the way in which policy developments affects further policy development. So policies produce new politics. And so that's something very important to kind of figure out how the ordering of things in sequence affects future ordering. And so this idea of path dependency is very important. We also tend to look for recurrent cycles or recurrent themes. So how do we see patterns in American political history, and how do we identify what those patterns or how those patterns develop and how we can identify the consequences of certain certain patterns and their evolution and manifestation in American politics. So a lot of this work is deeply historical, deeply qualitative in nature, and again, it means different things to different people, but it really also focuses on institutions and the way institutions shape how people act and how politics and policies develop over through time. So there's a lot of different, I think, nuances to American political development. There's a lot of different flavors of it. But I do think the one thing that we all take seriously is this idea that you really have to look at the big picture over a long term to truly understand where the United States has been, where it is today, and the possibilities of where it may go tomorrow, right, given kind of everything that we've seen in America's past, right? So I guess maybe I would even say, for a better bottom line, like a too long, didn't read version of American political development, it's that history matters, and it really does affect the future and the future course of political development in the United States.
But not history as mostly historians practice it, which would be to write a chronology, to be very, very precise about what came yesterday, what came tomorrow, and to mark it out in time that way. It's, as you said earlier, it's about cycles and patterns and the ways in which institutions are creating new patterns. Not that it's distinct from history, but it is somewhat different, as you point out in the book. How did you come to this? You went to law school, I assume, and so where did you pick up this penchant for APD?
Well, I think it really began in undergrad. I took a number of judicial politics courses, one by Professor Joe Ura, who's now the department head at Clemson. So it was a long time ago that I was an undergrad now. And we kind of went through some of the kind of big time works that have started to investigate and explore courts and the judiciary through American political development lenses and types of APD lenses. We would read, Gerald Rosenberg's The Hollow Hope, for example, which a lot of people might be familiar with. Keith Whittington's works on the political foundations of judicial supremacy. These are the kinds of things I was introduced to, and suddenly the law made a little bit more sense to me as being about more than just case law developed in isolation. I started to think about the way in which constitutionalism develops, and that was kind of where the seed was planted. And as I went through law school, and I somewhat realized, I was like, well, I've always had a penchant for teaching and research, and I really wanted to get into the academic side of things, and I realized that I had that passion in law school. I kind of revisited those old, kind of books and articles that I was introduced to, and started the path towards getting the PhD. And really my thinking on this has evolved considerably throughout law school and even after law school, where I really came to understand and appreciate that constitutionalism happens in many different places. And too often we really talk about constitutional law in a jurist-centric way. And by that, of course, I mean, we talk about the United States Supreme Court or courts generally alone and say, well, that's where law comes from. And I've just never believed that's true, right? Not only do judges and justices live in society, right? They're part of everyday American life. They get appointed by presidents and confirmed by members of the United States Senate who are elected by the people. And so their ideological dispositions are a function of who wins at the ballot box. And of course, right, we have all sorts of different things that we can think about how law changes us. I mean, I one of the perhaps most important moments for me, at least, to kind of discover this connection between politics and law was Lyndon Johnson's very famous speech on voting rights in 1965, when he called for the Voting Rights Act. Very famously used the term "we shall overcome," and in the front row of that joint session of Congress, where he's talking about the terrible things that were happening in Alabama, and kind of the suppression of peaceful protests in search for the right to vote. You had the United States Supreme Court justices sitting in the front row and clapping, right? Which is very kind of, it's an anathema to us when we watch them at a State of the Union, from showing any kind of emotion, perhaps save Samuel Alito during the Obama years. But they were very much part of this coalition, it seemed, right, in Congress, led by LBJ, that wanted to see this done. And then you see the case law that ratified the constitutionality of the Voting Rights Act in the subsequent years. And these are the people who sat in that chamber and heard LBJ call for the franchise to be protected for Black Southerners. And I think, for me, that kind of hit. I just had this moment of realization that these judges are not living in isolation. They are not hermetically sealed off from the rest of us in society. And so that, between that and the experience I had in my undergraduate courses, it really led me to think about law differently. And I think that's how I teach it today. I am very careful to tell my students that the way I approach teaching constitutional law is I teach them doctrine through time. And we take, I teach my law school classes very traditionally. It's Socratic method. We very much focus on texts and arguments and counter arguments, and we delve very deeply into the opinions themselves. But at the same time, we never talk about opinion outside of context, and we always talk about the social, the political, and the economic environment and dynamics that these decisions are being rendered in, because they are reflective of a lot of these periods too. And so if we want to understand the law as it's developed and the law as it exists today, we have to understand where it came from and the conditions that made it.
So let's dive into the chapters a little bit. The first sort of main chapter is called Jacksonianism and the Constitution of White Prerogative. And again, it's organized around a presidential election with an outcome that led to very particular changes in how politics was done, what kind of institutions mattered. So would you just flesh out a little bit what is so important about the Jackson period, and how does it change how we understand the Constitution?
Yeah, so the Jacksonian era, it's to me, it's a really fascinating era, because in many respects, it's not the first party system, right? The election 1800 is perhaps the most kind of transformative election in terms of major presidential elections. But what we see throughout the 1820s is the first real emergence of national political parties with political party structures. And part of the reason why I start with that is because, for folks who might be familiar with Roger Smith's work, ideas can be institutions unto themselves. And part of my thesis here is that the ideas that are brought in by major realigning elections like 1820, 1860, 1932, 1980, that these elections, like Jackson's in 1828, create new sets of governing conditions where these ideas, which become institutions unto themselves, dominate the political landscape for multiple generations at a time. And so if you could kind of understand the origins of these longer dominant coalitions and the ideological tenets that they espouse and that brought them and swept them into power, you can see and trace how that is reflected in American constitutional law over time. And so when Jackson comes to power in 1828, so much of his worldview, was about limited government and keeping the federal government, kind of out of, big infrastructure projects, that things had to be very much localized. Local sovereignty was everything. States were where the big decisions had to be made. There's this emphasis on well, I should say there's this kind of embrace of racism, right? Where Jackson presents himself as the hero of the common man, and also at the same time it's the white common man, and it's this idea that that you really have to protect, particularly slave owning interest from, kind of this emerging abolitionist movement and some of the kind of evangelical movements in the United States that are moral reformers. And there has to be a separation of church and state in order to help achieve that. The power to exclude is really important. But, you have to have the power to remove Native Americans from their land so that it could be, basically taken over by white settlement and made, I guess, ripe for, white Americans to kind of create this American democracy. And I mean, it's really, steeped in this idea of white supremacy. And so if you understand that that's a lot of what's animating the election of 1828, when you get to a point in time where Andrew Jackson and the Jacksonians have a really important contingent of justices on the United States Supreme Court, decisions like Dred Scott, which said that Black people in the United States had no rights that the white man had to respect, that Black Americans could never be truly citizens, that they were never intended to be citizens, and that there's, we have to create this entire constitutional regime based on this premise that America was made for basically white men. Yes, you could say, well, the 1850s, that's what a lot of people thought. Yes, absolutely. But you could trace some of those constitutional ideas all the way back to 1828. And so the idea that I'm trying to set up here in the chapter on Jackson is that, so much of the kind of small government, separation of church and state, hyper, focus on racial identity and protecting the interests of slavery. Nobody should be surprised of the jurisprudence of the Supreme Court in the 1840s and 1850s. I mean, it is very much reflective of what got swept into power in 1828. And you can trace that development through our politics and through our partisan, kind of party structures as they developed over time. And you can see how that somewhat is mirrored in the development and trajectory of American constitutional law. And again, this is the first kind of set of a pattern that I then try to demonstrate is replicated through different other dominant constitutional or dominant political coalitions and their regimes that they create.
And the next regime that really interests you is this Civil War moment in which we have the first Republican president and a serious change to the United States Constitution, which is, in some ways sounds straightforward now, but to Amendment 13 to get rid of slavery, Amendment 15 to give the franchise to Black American men, and the 14th Amendment to make certain rights hold states, not just the federal government, to these rights, transformed American government and policy. And you want to also add free labor into the mix because, as you said earlier, economics is always part of the threads of of politics and law, et cetera. So what happens in this period that is so fundamental to the change? And also, how is it both connected and also rejecting of the Jacksonian period?
So, one of the big things that people had to complain about in the Jacksonian era was that the Jacksonians and the Democratic Party of this period could no longer keep the country together. That this kind of pro-slavery tradition that had been developed was really tearing the country apart in places like Kansas, where settlers right from across the South and from the Northeast were battling it out over whether slavery should be introduced into a prospective new state of Kansas. The country just seemed to be being torn apart. You had the Fugitive Slave Act, which created a number of problems, especially in Boston, where you had a couple of high-profile fugitive slaves brought back to the South who had escaped to Boston, perhaps the most famous one being a slave by the name of Anthony Burns. It created a lot of tension in American society, and one of I think one of the things that's evident in the book, at least, is that the constitutional order could not withstand that kind of pressure forever. That something was going to have to give. It was just a question of what it was and how it was going to happen. And so the answer that the Republican Party began to hold on to was this idea of free labor, that there was this power grab by the slave power, right? The slave owning oligarchy, who was using black slave labor to their advantage and to the disadvantage of white workers. It's not really the most principled viewpoint. It's not this robustly radical anti-slavery position, though it is. But it's not we should free slaves because slavery is wrong. There's this idea.
It's not a normative argument. It's a means to an end argument. So whereas the anti-slavery people are making a normative argument, all Americans are equal, and African Americans have just as many rights, et cetera, just as much. Should have the same sort of access to politics and the economy. This is not that. It's a means to an end argument in which it's saying that in order for white workers to have the things that they want, they need free, quote unquote, free enslaved labor to go away so that the market will function in a different way. But it's not a normative argument.
Right. And so then so part of this free labor idea is also that the government should have some obligation to help people make something of themselves. So, America is this land that, this massive area where we have copious amounts of land and resources, and that the government should help facilitate people be able to use that bounty for their self-improvement. And so it's this idea that government can help people pull themselves up by their bootstraps in a way too. So, there's this idea of, it's kind of anti-slavery because it's anti-slave power. It's this, the national government has a role here to play. So it's a deviation from that local small government viewpoint of the Jacksonians, where they don't want the federal government involved in much of anything at all, right? So infrastructure is something that they see something as being valuable on the federal level. Something like the Federal Department of Agriculture, which comes about in the Lincoln administration, would be an example of how they could help people make the most of land and resources and the like to better their own lives. It's kind of has a laissez-faire kind of dynamic to it. And all of this is happening right in the 1850s and 1860s and is becoming a core part of the Republican identity. When you kind of mix that with the nature of the Civil War requiring a tremendous amount of federal government spending and investment, now you also have a new group of financiers and industrialists, right, who see the benefit of kind of a pro-business federal government mixed with this free labor idea, and you start to see the formation of a coalition of various people who can all come to agree on some form of free labor, right? Now, whether you're a radical Republican or you're not really that in tune with civil rights, but you're a financier and you want to make money. or you're some kind of moderate in between, whatever. I mean, people, can kind of make what they want of this free labor idea. And one of the critical junctures that really kind of cements what free labor was going to be for many, many years to come was the advent of a kind of a fervor for socialism in Europe in the early 1870s. And what the book tries to do is to highlight how these fears of socialism really dramatically affected how constitutional law was interpreted in such a way to be very much pro-labor, pro-business, or I should try to say pro-business, kind of anti-big labor. It was an attempt to allow the government to invest in things, but not regulate things. And so you slowly see the law reflect in American constitutionalism a principle that anything that remotely looked like the redistribution of wealth was wrong, that was somehow that would inherently run afoul of the Constitution. And it's an idea that many people in the legal community and maybe more broadly would say, well, that looks like the Lochner era, right? And that's something that we often talk about. Lochner being a case from the early 1900s. Essentially, it was a regulation of bakers, and it was done to kind of make bakeries more safe. The Supreme Court said, no, you're just trying to regulate the wage and labor relationship between an employer and employee, and you can't do that. There's a right to contract, and that's not something that you can violate. It's a constitutionally protected interest. Now, that idea of a right to contract, that idea of a laissez-faire constitution, it didn't begin at the turn of the 20th century in American constitutional law. It began much, much earlier. You can see it evolving in the 1880s and the 1870s, and you can see the roots of it in this free labor ideology that begins in the coalitional formation of the Republican Party in the 1860s, right? So again, this whole story is an attempt to, or this, I should say, that the kind of the picture I'm trying to paint of this era between 1860 and 1932 is that we can understand and we can better see how law, some of the outcomes that we see in constitutional law are telegraphed many decades before they actually manifest in constitutional doctrine. And it kind of supports this idea, again, that I really believe that ideas can be institutions unto themselves that have real gravitas in how Americans think, and consequently have substantial consequences for how American politics develop over and through time.
And just to clarify, so, in the general sort of law school class, the way Lochner is presented is as an argument about the 14th Amendment and what the word liberty and property mean, and the idea that this is held individually and the state cannot tell somebody that they can only work 20 hours a week or whatever the law was requiring, but they can't exceed these things. And what your American political development version of this is that it's not that they aren't making changes to what we now call substantive due process. It is that we need to understand that moment in law as not 9 people sort of sagely deciding, but rather as a result of all of these political processes and all of these pressures to create space for business to have more access to unregulated labor. They didn't want the government involved in mandating what minimum wage would be or maximum hours would be, or whether there would be bathroom breaks, or whether there would be animal feces in the bread, which was also part of that New York state law. Okay, so this takes us into the New Deal, which is in many ways a reaction to this building pro-business, sometimes laissez-faire, although as you also point out, it's laissez-faire, but they would also like the government to be able to support that, which is kind of like an interesting contradiction. So this, you present in the book, and as generally presented by historians, is a radical moment. And you call this chapter New Deal Constitutionalism. What do you mean by New Deal Constitutionalism? What happens on the court that's so important? And where are the roots of that transformation?
So when we look at the origins of the New Deal and some of the major themes that FDR and his administration kind of brought into the mainstream American politics. It's this idea that government has to be pragmatic and responsive, that government has to be able to intervene and provide policy prescriptions for economic and social ills. And if it doesn't, and if the government fails to be able to address the needs of people and really fails to provide substantive responses to the things that people need in their everyday lives, that there's also a harm to democracy there, and that there are democratic interests in having a government which can be responsive and pragmatic and interventionalist. And so you see this argument that the government needs to basically provide people with robust public policies that attempt to address their everyday issues, that we have to respect the right to organize because there's an important democratic value there too, and that if we can do all of this, that there's that the United States can kind of stave off the anti-democratic collapse, or I should say anti-democratic waves that caused the collapse of parliamentary democracies all across Europe throughout the 1930s. And so part of that as well is an understanding that the United States has to be different than the kind of democratic failure based countries, or the countries that experience democratic failures, because what was seen there was something antithetical to what America should stand for, that there should be a respect for civil rights, there should be a respect for religious minorities, there should be a enhanced awareness of any attempt of the government to suppress free expression of ideas or anything like that. And so these kinds of issues really come to the kind of the fore of what it meant to be a mainstream Democrat, and to be a mainstream politician throughout the 1930s in response to the Great Depression and in support of the New Deal. What's really kind of becomes interesting is in the late 1930s, there's a huge movement, of course, in the United States' population, where you have a lot of Black migration from the southern states to more northern states in search of better economic opportunities and to escape, the horrors of Jim Crow that's occurring in the South. And this creates a new constituency for the Democratic Party, where you had voters who were willing to vote for the Democrats, right? And these are voters who Black voters in the North, who, unlike Black voters in the South, can exercise the franchise, and so they can wield influence. And so what the book shows, and it kind of builds on a lot of other great work on labor history in the United States, is that there's this relationship that gets built between big labor and Black voters that become a huge core part of the Democratic Party constituency in the North, that begins to emphasize how important and how interconnected both union rights are and civil rights are for Black Americans. And so as early as the late 1930s, you start to see the seeds being planted within the Democratic Party, where racial equality and a commitment to radical democracy become incredibly important, because of these new constituency-based interests. And it marries well with this other kind of pre-existing theme in the New Deal coalition, which is a protection of democracy from illiberal forces, particularly in the wake of authoritarianism gaining ground throughout the world. And so, for many great reasons, obviously, right? It goes without saying, we celebrate Brown versus Board of Education in 1954 as being a radical development in the protection of the law and what equal protection means, in terms of protecting Black Americans and preventing racial discrimination by the state. And of course, that is a hugely transformative moment, but it's neither the beginning of the story nor the end of the story. And I think that that's really important for us to understand that Brown versus Board of Education is the byproduct of a longer, sustained period of litigation. It's a byproduct of regular politics at the ballot box, where the Democratic Party becomes increasingly responsive to the needs of Black Americans. It's also a response to broader politics of the world and in the United States, where you have an emerging and burgeoning civil rights movement on the ground in the American South. And at the same time, the United States is very hypersensitive to anything that could be shown to the outside world, particularly in communist countries, that makes the United States look, that can paint the United States in a negative light because of the terrible treatment that Black Southerners were receiving. And so it's a byproduct of a lot more than just an objective meaning of the Constitution, right? I think 90% of Americans would say, objectively, of course, Brown versus Board was correct. But it's really a lot more than that, right? It took a lot more hard work on the ground by many different component pieces to make that a reality.
So what we see is from 32 is that FDR and the New Deal, even when Republicans are ruling, such as Eisenhower during Brown versus Board of Education, we're still in what you would consider to be a very sort of similar kind of constitutionalism and a similar kind of politics. There is support for federal activity, even if there's differences about how the government should act or the particular priorities it should have. And what you see, though, in the election of 1980 of Ronald Reagan is the chipping away confrontation of this New Deal constitutionalism. What you see is a call to reduce federal power, to be suspicious of regulation from the government, and to begin to question the expansion of the kinds of rights that were extended to African Americans. And this is a period in which we're seeing women assert that even though they're not mentioned in the Constitution until the 19th Amendment, that they too have certain rights. And this podcast should come out after my interview with Joanna Beast, who has written a really interesting book called Born That Way about the expansion of rights for LGBTQ plus people. So this is a very complicated moment in which Reagan presents this very multifaceted hostility. What happens on the court that we sort of should be focused on, and how have we missed when we only look at a legal framework or we only look at the words of the justices, something else that is going on?
So one interesting recurrent pattern is that it is not an uncommon thing for a court to outstay its ideological welcome. And so a court very, very oftentimes reflects the old dominant coalition, which creates a significant amount of tension with a new incoming coalition, right? This is, of course, going back to what we talked about with Marbury versus Madison, right? The old Federalists on the court kind of in tension with the newer members of the Jeffersonian regime. Right? 1860s, we had a very contentious relationship between radical Republicans in Congress and a lot of the Democratic leftovers who were on the Supreme Court. We perhaps the most famous one of this kind of pitched, this kind of pitched battle between the courts and the political branches was in the 1930s, where the court rejected New Deal initiatives from the FDR administration and the New Deal Democrats, and eventually Owen Roberts was the switch in time that saved 9, allegedly. And right, there was an attempt to pack the court, and there was a huge, massive election victory for the Democrats in 1936. And the too long to read version is the court caved and eventually started approving of New Deal policies. With Reagan coming in 1980, we don't really have that kind of deep division between the courts and the Reagan administration, although there are issues that Reagan obviously had with the courts, as the book shows. But there was kind of the slower slide into judicial conservatism, in large part because Richard Nixon had the opportunity to appoint a number of justices on the Supreme Court who were kind of moderate Republicans. And so in the 1970s and into the 1980s, there was this kind of lukewarm conservatism that had taken over the court after many years of the Warren Court's liberalism of the 1950s and 1960s. But Reagan still wanted to do a lot more and wanted to totally reinvent the way in which American constitutionalism and the way in which the constitutional order worked, reducing the size of the federal government, bringing power back to the states, limiting a number of civil rights initiatives. Anti-abortion becomes a kind of central focal point of the Republican Party doctrine in the 1980s. Social conservatism more broadly, takes root, and the court, slowly starts to reflect this. Winnowing away at abortion rights throughout the 1980s and 1990s, with Casey versus Planned Parenthood in 1992, we have a really major step back in abortion rights from Roe versus Wade, in large part because you had a remaking of the federal judiciary and the United States Supreme Court by Ronald Reagan and George H.W. Bush. Over time, you see similar pulling back of the Commerce Clause powers during the Rehnquist court's years, where the Supreme Court said that the federal government had had a real hard limit on how much regulation it could adopt, and that was reflective of the Reagan Revolution's purpose, or actually the revolution's goal of limiting the scope and size of the federal government. Now, the other thing that's interesting here, and this is something that we touched on very early in our conversation, is this idea of path dependency. Not everything was going to be able to be undone by Ronald Reagan because people became reliant upon things. So you're not going to basically be able to get rid of Social Security and Medicare and Medicaid because people, once you become reliant upon it, or you depend upon it, or you think it's going to be guaranteed for you, you're going to feel like you have a vested property kind of interest in it. Same thing with some other forms of regulation, the Department of Education, the EPA, and things of that nature. So while the government, the federal government in the Reagan years tried to winnow away at the federal government, they realized you couldn't completely throw everything out and kind of return to a much more simplistic state of federal power. And at the same time, I think the Republican Party slowly began to realize that they could take this federal infrastructure that had been kind of created by the New Deal coalition and turn it into something that they could benefit from themselves, right? They could kind of turn it into a pro-social conservative state. And so, that's a big lesson of, I think, in American political development, is that the choices that governments make decades and decades before, at kind of a new point in political time, or a new moment in American political history, affect kind of the policy choices that people have. And I think the federal government, the Republicans of the federal government recognize that, and the Supreme Court also recognized that. So while the Supreme Court's doctrine over the last 40 years has been much more in favor of states having control of things, much more in favor of reducing the size and scope of the administrative state, kind of limiting the ability of federal power and the power of Congress to regulate certain kinds of conduct, it hasn't totally reversed course, because that would just bring the entire system down. And so they have done, I think, the Supreme Court has done as much as it has as it could, particularly in the last few terms, to bring the Reagan Revolution fully into constitutional law and into the constitutional canon. But they really can't do everything that Reagan initially set out to do, again, in large part because some of those decisions that were made in the 1930s and 40s and 50s and 60s have become so ingrained in how Americans think about what the government owes them and what the government should be able to do for them, that you can't entirely throw that out altogether.
So you really bring this book to the present, which is something I really appreciated about the story, because sometimes history is important because you need to really specify what happened in a particular period and understand it and dive deep. And those kinds of scholars that give us that kind of insight into a particular 10-year period are the people that we rely upon to write books like you've written. But that's not what you're trying to do here. And you really are almost always keeping where the court went in focus throughout. And you often cycle back to it, even as you're talking about the Civil War. This has been described as a very special moment in the Supreme Court. It's a highly ideological court. It's an extremely conservative court. What did the work on this book do to change how you feel about today's Supreme Court? Or what particular insights do you think the kind of work that you've done gives us into today's Supreme Court?
So I think the big takeaway for the book is that the court's usually majoritarian, right? It usually reflects majority views. But, now we have a court that's been reshaped by Donald Trump, who never received a majority of the popular vote, lost that twice. Never really received a majority of the kind of public opinion polls while he was in office, and yet got three people on the court who were all basically confirmed by a Senate that was malapportioned, right? The Senate doesn't look like America. It's not reflective of America as a whole, and the number of senators who voted to confirm those justices represented a minority of Americans. So now we have this kind of minoritarian interest entrenched. And that seems to brood a lot of problems for a court that has, only judgment. They don't have power of the purse, power of the sword. And so what do you do then? And now that you have all these kind of bombshell cases on abortion and voting rights and the administrative state, and it seems to kind of never end, right? Where what they're going to step in next, that seems like a recipe for disaster.
Do you think there's anything that could affect this? I mean, we have 6 conservative justices who were appointed by either Donald Trump or one of the 2 Bushes, and then we have 3 justices appointed by Obama and Clinton. What could happen? What could the other branches do? You're correct that gerrymandering and minority rule make this quite difficult for Americans to register what they do want. But is there any insights from these previous presidential elections? Is it possible to have an election in 2024 in which the court is the focus? Is that something that's ever happened before?
Well, I think it certainly was at the forefront of conversations in 2016 because Justice Scalia had died in the middle of the presidential campaign. And so it was a big issue, especially for Republicans who were motivated to vote. And I think the same thing is now true in the reverse, perhaps. Here's the one thing that's so interesting is President Biden has historically not been one who was willing to be engaged in constitutional hardball with the court. He's taken some very antagonistic positions towards the court, but only recently, right? This year, has he endorsed real court reforms, constitutional amendment to undo presidential immunity, maybe a constitutional amendment, maybe a statutory proposal for term limits for the Supreme Court of 18 years, and real reform in terms of Supreme Court ethics in light of some of the scandals that have emerged about justices receiving huge sums of gifts. That's a really big shift in the conversation. And so people have talked about court packing before. Maybe that now becomes a more mainstream position now that somebody like Joe Biden has adopted some of the other ones. We'll have to see. But I think that, no matter what, that's kind of a shot off the bow to the court that they need to come to heel. But that only works if Kamala Harris wins in 2024. If she loses, then, questions about, what happens to the court, I think, become moot because, then it seems like the public has ratified the Roberts Court through Donald Trump. And so, I think a lot's riding on what happens in November of 2024.
Well, thank you so much for joining us. I've been talking to Dr. Anthony Michael Kreis about his new book, Rot and Revival: The History of Constitutional Law and American Political Development, published by the University of California Press in 2024. Thanks so much. And it's a great book and highly recommended. Thanks for taking the time to talk with me.
Well, thanks for having me.